We have had some problems with our technology, but we're now, I think, ready to resume. Miss Jordan.
My Lord, we commenced before lunch, just putting the matter in context as regards a former trustee and the particular circumstances that ETJL faced when it was passing over the assets. Can I now turn to look at, really from first principles, what the nature of the indemnity is, and also take the panel to just a few cases which you haven't yet been taken to, as regards what happens to that right after a new trustee takes possession of the assets. And then I will move on to Jersey law to see the position in Jersey law as opposed to English law. So starting with really first principles, and I don't need the panel to turn up these cases, but it appears our written case, which is at page 771 of the bundle. And at paragraph 16 there, we quote Re Blundell in 1889, which states, "What is the right of indemnity? I apprehend that in equity, at all events, it is not a right of a trustee to be indemnified only after he has made the necessary payments to his solicitor or the auctioneer or to the stockbroker, but that he is entitled to be indemnified not merely against the payments actually made, but against his liability." And of course, as we know, that includes contingent liabilities, which again, that is what we're talking about here. And in our case, in ETJL's case, we novated all the other liabilities. So it was clear to the new trustee that the liabilities which were left over would be future and contingent as regards our client. Moving down on the same page, that 16 paragraph 3 refers to Re Grimthorpe in 1958. And there it stated, "It is a commonplace that persons who take the onerous and sometimes dangerous duty of being trustees are not expected to do any of the work on their own expense. They are entitled to be indemnified. The general rule is quite plain. They are entitled to be paid back all they have had to pay out." And just pausing there, these are onerous and difficult duties. One only has to look at the risk that ETJL faced in relation to the assets. If you consider the value of those assets when they passed them over, even given the liabilities, they were hundreds of millions of pounds. So what you were talking about is significant liabilities in terms of a contingent claim against them because of the total value of the fund. The third general proposition is on the next page, so 772 of our written case, and that's Riexel Coal Company. And again, the panel has been taken to this several times, but it is described as a right incidental to the character of trustee and inseparable from it, that he should be saved harmless from obligations which are attached inseparably to his office, and by which anyone taking a charge from the Cestui Trust is bound. And that is the key point in relation to these starting principles. This right is incidental to the character of trustee and inseparable from it. And that is absolutely key when one starts looking at the nature of that right, particularly for a former trustee who again doesn't have the assets. Just to finish that point, the panel was taken this morning to Worrell, and I don't need to take you to that, but it is a similar point, and that is at 2483 in the bundle. So that is really starting from very much first principles. And as Lord Briggs said yesterday, we really have to do that in relation to this case, because none of the English cases really have dealt with the particular circumstances that ETJL find themselves in, which is insufficient assets to cover both their contingent liabilities which have been paid out and the other creditors to the trust who claim through the current trustee. And in those circumstances, the question of priority then becomes absolutely key. I have to accept, as we do at our written case, and this is paragraph 17, that there are differing words used, and the panel will be very familiar with that now. You've been taken to a long list of these cases where there are differing words. So charge, lien, first charge, charge or right of lien, a lien on the trust fund. All of these phrases are used, and they are used in the older English cases as well. Now, as was said yesterday, for the purposes of the English cases, the point simply hasn't been looked at. So the question of priority simply hasn't been determined in English law. But having said that, the term an equitable lien or an equitable proprietary right is helpful, particularly when you come to a former trustee. And the equitable lien is helpful because although it has difficulties being compared with other equitable liens, and I have to accept that as well, but it does connote an equitable right over the property without possession, which doesn't depend on possession, and that right arises by operation of law. And so to that extent, the term which is used as equitable lien is helpful. Now, the criticisms which one sees of the term equitable lien, and again, the panel has looked at those kinds of criticisms, those criticisms really relate to it not meaning very much if you are a current owner of the assets. But that is in distinction to a former trustee who has given up the assets. And for a former trustee, the term equitable lien, which connotes something which is without possession by operation of law and creates a right over those assets to come and claim them directly, not subrogated to the current trustee's rights, that is helpful in terms of a general description. And in my submission, that really is what the older English cases are concentrating on. And that is the extent of what they are describing there. Now, you will have seen, and we touched on this morning, in the more recent Australian cases, the term has slightly changed to a preferred beneficial interest. My learned friend, Mr. Torb QC, will be dealing more with those cases, and that's the line of authority which is Buckle, and then Augusta, which I will touch on just to introduce that, and Bel Air. And really, we say that that doesn't change the nature of the right. And again, it's almost going back to this morning's submissions, because we agree that the label given to it isn't necessarily helpful. What one has to analyse is precisely what, in our case, the former trustee has. what right does it have? Which is why I started by saying, for us, this is about rights, not about relationships. So that being said, sorry.
Or I was just going to ask, Mr. Jordan, but do you accept that if we're dealing here with an equity that arises by operation of law, it has to conform to some recognised, I'll call it legal entity, some recognised interest? In other words, I mean, I take your point. You've got to look at the nature of the right, but if it's being exercised via a lien or something like that, then one's got to be able to say what the manner of the exercise is, what the vehicle for the exercise is, haven't you?
Yes, I agree that it is of assistance to say this is how you exercise that right. But the key point for a trustee and a former trustee is that they have separate rights of indemnity. And that is the key difference. So that is the key difference between our case and between the Jersey Appellants case. For the Jersey Appellants case, to be correct, all we would have is a personal right as against the current trustee once we gave up possession. That is all we'd have. We wouldn't have our own claim as against the assets. That is the key difference. And that is why we say that actually it's that separate right of indemnity that we claim against that is key. It's that distinct right rather than the current trustee's right. Lady Rose, I'm sorry.
Yes, but I understood Mr. Matchell this morning as asking that there was a separate right. I'm not sure whether
Yes.
Ms. Stanley and Warnock-Smith also accept that, but certainly Mr. Matchell accepted that.
Yes.
In answer to my question, that they're not then affected by any depletion on the part
Yes.
of the right that the current trustee has. But obviously then there is another difference between you because you are arguing for different outcomes. So,
yes.
So what is the other difference then that you say leads on from that?
So the other difference is the way those rights are treated in terms of priority. That is the difference between myself and Mr. Matchell. And I say that because Mr. Matchell helpfully described his submissions as if you are against the Jersey Appellants. So this is the key difference between my case and the Jersey Appellants case. But it isn't a difference between my case and the Guernsey Appellants case. It is that distinct right of indemnity which is key. Now, we describe that as an equitable proprietary right. And I will come on to how one might see that operating in Jersey law, because there are a number of ways of looking at it in Jersey law. And I'll take the panel through the various ways that we have considered so far. So the idea of a non-possessory lien, the idea of an equitable lien, but also the idea of an equitable proprietary right or a beneficial interest in the trust fund. But all of those are in fact more permissible than you might think under Jersey law. And I'll take you through that. So that all being said, the particular cases which I wanted to concentrate on before we move to Jersey law are those cases which you weren't taken to this morning, I think partly because of time, but these are the cases which suggest that the equitable lien of or the equitable proprietary right, the equitable lien of the former trustee survives in the fund and that the new trustee takes subject to that right. Now, Mr. Taub QC is going to deal with the priority that is given as regards that. All I'm going to concentrate on at present is what the cases say in relation to that right. So if we can start, please, at Dimos and Dikiarkos, and that appears at 2842 of the bundle. And if I could ask the panel, please, just to read the head note, because what that should make clear is this concerns a former trustee. So if one looks at the top, indemnity lien reimbursement, right to indemnity survives trustee's loss of office. And if you move down to one can see the facts appearing at page 2845. Basically, the appellant was a solicitor for the respondent, and the respondent was trustee of a trust. He resigned in 1994 and a new trustee took over. And then there were actions for unpaid legal fees by the appellant against the former trustee. So this is a case of a former trustee, rather than those cases that we've been looking at where you have a current trustee and there's a question of the right of retention. This is looking at the position of a former trustee. And if we can go to page 2853. And there is the passage which begins, it was common ground that at least prior to retirement, the respondent had a right to indemnity against liabilities incurred in the discharge of the trust. For the purposes of enforcing that indemnity, the respondent had a charge over the assets of the trust which took priority over the rights of beneficiaries. The respondent acquired in the assets of the trust a beneficial interest commensurate with his right of indemnity. And there you see that term coming in, and we'll see that as well in Augusta. The right of indemnity exists both for the discharge of liabilities incurred but not paid, and for reimbursement where the trustee has paid. And then this right of a trustee is an incident of the office of trustee as inseparable from it. And moving down, in my opinion, that right of indemnity did not cease upon retirement. And then they refer to Coates and McInnery. And if we move further down to the next substantive paragraph, there is no reason why the fact of retirement from trusteeship should result in the abandonment of property, that is to say the interest commensurate with the right of indemnity to which the trustee is beneficially entitled. Although the right of indemnity undoubtedly confers a right to retain possession of the trust property, it is also a proprietary right equivalent to and ranking ahead of the interests of the beneficiaries. As such, it is probably not dependent on the retention of possession. And then, in any event, in the present case, the respondent retains the legal ownership of the properties and can thus exercise a lien in the strict sense. Now, pausing there, if one assumes, for present purposes, that you have the equitable lien rights when you have legal ownership of the assets, then it is difficult to see why that position should change when you retire from the trust. And if we move on now to look at Augusta, which is at 2526. And again, My learned friend, Mr. Torb, will be dealing with this case in more detail, so I don't want to take the panel all the way through it. But Augusta is important because it deals with the precise clarification of this preferred beneficial interest point. So if we go down to paragraph 41, which is on page 2526, the right of a trustee to be indemnified out of trust property is often described as a charge or lien, and then they quote Octavo and they quote Buckle. Again, that is the case which deals with matters saying it is a preferred beneficial interest. The High Court preferred to regard it as a proprietary right constituting a beneficial interest, enjoying priority over the beneficial interests of the beneficiaries. It is anomalous to refer to a person having a charge or lien over property over which the person is the owner. And as was emphasised in the High Court, subsequently in CPT, trust fund enjoyed by the beneficiaries cannot be identified or quantified until the trustee's superior beneficial interest has been quantified and satisfied. The trustee's right is inseparable from and coextensive with the trustee's obligations, both those already discharged but not yet reimbursed and those incurred but not yet discharged. And then moving down that page, there's the heading, the effect to transfer to a new trustee. And they start, it is necessary to consider the consequences as regards the trustee's preferred beneficial interest. There's that different term, or of a transfer of trust property by the trustee to a new trustee. And at 44, after such a transfer, the original trustee's preferred beneficial interest continues to subsist in the trust property in the new trustee's hands. And that was recognised in Bel Air. And as I say, Mr. Torb will be taking you through those cases in more detail. That's really just to introduce Augusta and the importance from my client's point of view of that case is that point at paragraph 44. So if one sees this in the terms of the most recent Australian cases of describing this as a preferred beneficial interest, it still means that you continue that interest. It continues to subsist in the trust property in the new trustee's hands. Now, the key point about that is that the new trustee takes subject to the previous trustee's equitable rights, preferred beneficial interest, or equitable lien. And it is for that reason, and I'll take the panel to this, when we look at the specifics around Jersey law and Jersey law recognising this equitable lien. But in the Commissioner's judgment in February 2015, he did recognise the existence of the equitable lien, and he stated that equity had the right to ensure that the successor trustees do not take steps which will destroy, diminish or jeopardise that right by which they are bound. The reason that principle exists is because the new trustee takes the assets subject to and bound by the former trustee's rights over those funds. And there are comments in exactly the same form. So if we can look at Lemery at 3138. And it appears at the top of that page This is the 8th proposition which is cited. Eighthly, if the trust property is transferred to a new trustee, the lien survives and the new trustee takes subject to the lien of the old trustee, except perhaps in the exceptional case of a bona fide purchaser for value without notice. So that would be the exception to this particular principle. But otherwise...
Sorry, could you just give me the reference again?
Yes, I'm sorry. It's Lemery, which is at 3138.
3138, sorry.
Yes. And it's paragraph 21 at the top of that page.
Very much.
And then also on Lemery, if we can just move down to 3140. This is the criticism which is made of Lemery by the Jersey Appellants. And what is said there is that the judge refused to accept or denied Repauling's settlement trust and Inri Suco Gold. Now, what actually Beraton J did in these passages, and I won't take you through these in detail, but as regards repooling, he considers that at paragraph 31, and he correctly states that Wilberforce J in that case considered the right of retention against a successor trustee and wasn't considering anything as regards the equitable lien. So there, thus, while repooling settlement trust suggests that an outgoing trustee is entitled to insist on retaining the trust fund as against the new trustee as security for its indemnity, it appears to overlook the cases that hold that the security survives and is enforceable against the assets in the hands of the new trustee. And also, he considers then further down the page, he considers Inri Suco Gold, and he concludes that the comments about a new trustee in Suco Gold must be obiter because there was no new trustee in Suco Gold. And that is quite right in terms of the facts of that case. And then finally, if we can, before moving off this point, if we can look at Ron Nouri, which appears at page 3426. And if we look at paragraph 14, if we can pick it up at 14, that's page 3425. It is axiomatic that a trustee has a right to be indemnified out of trust assets against personal liabilities incurred in the due and proper performance of the trust. Furthermore, the trustee has a beneficial interest in the trust assets to the extent of that right. The interest is a proprietary interest. So much was recognised in the judgment, and then he refers to Buckle. And again, that is that beneficial interest in the trust assets which Buckle talks about. And paragraph 15, moving down, in the present case, the former trustee continues to enjoy a beneficial interest in the trust property commensurate with its right of indemnity out of that property. And then although the trustee's right to resort to trust property is sometimes described as a lien, it is not essential for the enjoyment and affectation of the right that possession of the trust property be retained. The right entails, as I have said, a beneficial interest in the property. It is not in the nature of a possessory security. Now, we will look at this in when we move on to Jersey law, but there is a conflation in the Jersey Appellants case between the right of retention and the equitable lien rights. And that is what is being distinguished here. So we would say that Article 43A, new 43A, previously 34.2 in Jersey is all about a right of retention. And there are limitations on that right of retention, which we will go to. And the particular limitations are how the Jersey courts have dealt with what reasonable security means for the purposes of that right of retention. But that is different. One needs not to conflate that ability to retain assets, which is really what the cases dealing with reasonable security in Jersey have looked at, as opposed to the equitable lien rights, which may well look to be forced upon later, to be claimed later by a former trustee in the event of, for example, a contingent liability, a claim against them. But if I can, just on that right of retention point, before we leave this and look at Jersey law, can we look at Lewin, please, which is at 4195. And it's paragraph 17056 of Lewin. Could I ask the panel, please, to read that paragraph? And also, could we also move down to 17061? And could I ask the panel to also read that paragraph? (17061) in particular shows the difficulties, the very real practical difficulties that would arise if it is suggested that it is satisfactory to leave a person who is no longer a trustee in the possession of the trust property. And in particular, the point about questions arising as to what powers of management, if any, were retained by the former trustee, despite his departure from office. And if one pauses there, and I will come back to this point when we look at how the Jersey courts have dealt with that question of reasonable security, but one can see standing back that it would cause very significant issues if actually the former trustee somehow, in order to protect itself against contingent liabilities, was required or encouraged to take some form of possession or legal charge over the entirety of the assets of the trust before leaving office. That is a significantly difficult principle, particularly because of these points that arise in paragraph 17061 of Lewin, because there are then questions of, well, what happens about the investments and how are the assets actually dealt with? And in fact, that is the reason that this question of the right of retention is actually really quite limited when a former trustee passes over possession of the trust property. And in my submission, that is quite right that it is. Because if you do away then with this additional protection, you put the emphasis on a former trustee who is looking at their contingent liabilities. They are well aware of what the fund is worth at that stage. So they're aware of their risks in terms of liabilities. They're passing over the trust assets at that stage. And what you are basically then saying is, how do you provide for those contingent liabilities during a period of, under Jersey limitation periods, for an action personnel mobilier, for example, that's 10 years. In our case, it was a period of 6 years. So you would be tying up the assets for a significant period of time if actually this was all about the former trustee getting a right over those assets of possession or legal charge. And that is simply not the policy of the Jersey courts, and nor should it be, for the reasons that Lewin states. Yes.
Lewin goes on in the next paragraph to say that more often the retiring trustee is protected by express indemnity and, where appropriate, express security arrangement.
Yes.
Rather than by his general legal right.
Yes. Now, the difficulty with that, Sir David, is that if you want to take express security, then you need to know the extent of the liability that you are facing at the time. Otherwise, the express security is no good to you. And so the difficulty with a contingent liability is what you're actually looking at as a former trustee is, in reality, my risk. And this is where I go back to the onerous nature of trusteeship. What I am really facing is liabilities up to the value of the fund in my hand during the period that I have been trustee. And that is why the key point is it is those liabilities which are absolutely fundamental for a former trustee. And it is why this equitable proprietary right is key for a former trustee, and particularly in our circumstances. Yes, Lady Rose.
So is this common ground between you and the appellants that the right, the extent of the right or all its incidents must be the same whether the trustee retains possession or passes on possession to the new trustee, and those rights either give it priority or they don't. But if they don't, it's not in any better position by having taken security or having held on to some of the assets, unless in effect by doing that it prevents the new trustee from squandering them in some way, in which case of course it's retained them and kept them safe for everybody's sake. But do you accept that, or is what you're saying that you accept that whether or not assets are retained or security given in lieu of retention of the assets, that can't improve the rights, the incidents of the trusteeship in this way? It might make them more valuable, but it can't actually increase the nature of the rights?
Well, I don't necessarily say that. The point about security is that if you know a liability when you hand over those assets, the best thing for you to do is take possession of those assets, because then, to be frank, you would not be in the position that ETJL is in, where we've had 6 years of litigation. You would have possession of those assets, and then you would say, I am a legal owner of those assets. So we have a distinct situation in the Guernsey and the Jersey appeal, because the Guernsey respondents do have possession of the trust assets, and that's because they were aware of the possibility of insolvency at the time. We weren't, and that's really the difference. So ideally, you would take possession of the trust assets, and you would say, I will then use those.
Right, so suppose as the trustee, you know you've got a contingent liability that's, say, worth £10 million. You keep hold of £10 million of the trust assets.
Yeah.
And the rest of the assets go to the trustee, the new trustee,
yeah.
who then incurs all sorts of other liabilities and fees, and the trust has no longer got any assets. Now, you as the former trustee, you still have hold of the £10 million, but that doesn't necessarily mean it's security still for an indemnity worth £10 million. It might now only, if you only have a right pari passu, it may only be now your right has to be written down to only £4 million, because you have to share all the assets, including that £10 million, amongst all the different trustees and creditors. But are you saying that if you hold on to that £10 million, regardless of what other calls there are on the totality of the trust assets, including that 10 million, you're still entitled to that 10 million in some way?
Well, so the way that that security would work, Lady Rose, is you would negotiate that security. So what you would say is it would be an agreement between you and the new trustee coming in. You would say, I'm aware of a liability for 10 million. I'm going to get sued next week, and that maximum liability, legal fees and liability, is 10 million. So I want you to agree that 10 million will come into an escrow account, and that will no longer form part of the trust assets. So it is ring fenced for me to then use as against my liability. That would no longer form part of the trust assets, but that would be by way of agreement with the new trustee who is coming in. And if that couldn't be agreed, and this is all to do with the right of retention, if that couldn't be agreed, then you can then go to court in Jersey, and you would say to the Jersey court, this is what I consider reasonable security. And the Jersey court would either agree or disagree. And you would say, I'm not resigning until I get that reasonable security.
But by taking that as security, you say you take it out of the trust funds.
You agree with the new trustee coming in that that will be your security as regards that particular liability. So it will no longer fall to be dealt with by the new trustee in the way that they can deal with all of the assets. And those kinds of questions, so for example, whether that is reasonable or not, that is a key question when the Jersey court is considering those kinds of points about this right of retention. What does reasonable mean in the context of security? Because it has the effect of taking those assets out of the fund. Now, as you'll see, Lady Rose, that when we look at the cases in Caversham and the other cases, they really don't deal with contingent liabilities at all. Because what we haven't had is a situation where somebody has come to court and said, I have this liability and it's 10 million. So they haven't dealt with that kind of liability. What they've dealt with is fees and expenses of the trustee, which are normally the things left over when you're retiring from the trust.
Right, but in your example, just to push this a little bit, in your case, then if the former trustee held on to that £10 million, and in fact the liability turned out to be 10 million, but the trust was insolvent in the way we've been explaining, if the current trustee came and said to the former trustee, yes, well, you had security for £10 million, but actually your indemnity is now only worth £2 million because everybody has to accept only 20% of what they're entitled to. So give us back the £8 million. You would say no.
Yes.
It's not only security for my liability, but it fixes the liability in a way that protects it from any further diminution because of other subsequent debts.
Yes, yes, it takes it out of the fund. It takes it out of the trust fund, but that has to be by way of agreement or by way of court order under Article 34(2) and what is 43A. With those comments all being said, can I now move to the position in Jersey law? And can we start for these purposes with just a reminder of the first principles that we looked at, and those principles, and those were re-Exel, re-Blundell, re-Grimthorpe and Worrell. Those principles are as applicable in Jersey trust law as they are in English trust law. And those statements apply with exactly the same force that they do in for a Jersey trustee as they do for an English trustee. And that is particularly the case because of the importance of the trust industry to the island. So as a starting point, there is no reason that we shouldn't start from those cases. And indeed, that was one of John Martin's points in his judgment. The point I think you were taken to in relation to the inconsistency of Jersey law was the point of the bailiff, and really this is in relation to movables not being capable of being hypothecated. That is the point that the bailiff makes. And if we can turn to that, it's at page 445 and paragraph 269 of the Court of Appeal judgment. And you were taken to this by Mrs. Warnock-Smith. And there the bailiff states the established principle of Jersey customary law, and Jersey practitioners know that until the passage of the security interest Jersey law, no security over movable property was possible as a matter of Jersey law, except to the extent that the court recognised a pledge accompanied by the delivery of possession, as well as various liens, such as the lawyer's lien, over papers belonging to his client where the person claiming the lien already had possession. The effect of the 1983 law was to introduce for the first time a regime by which it was possible to take security over movable property provided that one followed the framework of that law. That law has been superseded by the Security Interest Jersey Law 2012, but in neither case has the old customary principle been expressly abrogated. My preliminary view is that the customary law principle continues, save to the extent that any prospective security arrangement falls directly within the four corners of the new legislation. Pausing there, that the bailiff did not formally dissent, as you will have seen, and this point was never argued before him. So this is very much his preliminary view, because we didn't have the opportunity to argue this point, because the Court of Appeal considered themselves bound by the decision of Investec. So if I can start, please, with looking in Jersey law at the nature of the hypothek. If we can go first to our written case. I'll just turn up the paragraph. And you'll see there the position under Jersey law starts at page 784 of our written case, and it's paragraph 30. And at paragraph 33 of the written case, and moving further down, there is a description of how the trusts law came to, as Professor Paul Matthews puts it, creep in to Jersey law prior to the 1984 law. And if I can ask, please, the panel to read paragraphs 33 to 36, please. I'm grateful. So the point being that the starting point, and this is largely from Professor Matthews' article. Now, that appears, I won't trouble you with it, but if you do want to read that, it's at 4371 in the bundle. And at page 4373, this is where Professor Matthews describes how he describes it. The trust, the concept of a trust creeps into the Jersey legal environment. And this is prior to 1984, the statutory. Then you'll see at 37 that the well-known case of Abdul Rahman, there the deputy bailiff stated, in other words, trusts of real property created by contracts inter vivos existed. The court had recognised them and had given effect to them, but no statute had been enacted. The position was not very different from that in England, as shown by the evidence given by Sir J. Audrey. In England, you appoint a number of trustees. You never wait to let it descend to the heir. for as the number of trustees is reduced, you fill them up again. And then moving down, the court in Rahman was also referred to Godfrey and Godfrey, and after quoting from that case, the deputy bailiff concluded, so here we find an irrevocable settlement trust of both movables and immovables created in 1835 and upheld by the Privy Council in 1865. We do not share Mr. Hammond's criticism of this judgment. As a decision of the Privy Council, our ultimate appellate tribunal, it is binding upon this court. So what one sees is, at least from the 17th century onwards, there are examples of trusts being used in Jersey law. And that is likely developed from Roman law concept, so the fideicommesse, in exactly the same way as the English law was first developed. Before we move off Abdul Rahman as well, just paragraph 40 of our written submissions on the same page. The Deputy Bailiff from Rahman heard argument that the Jersey court, unlike the English court, was not a court of equity. In response, the Deputy Bailiff concluded the court was not persuaded by those arguments. It is now beyond question that the court is a court of equity, and in many cases it applies equitable remedies. And that is the distinction with the concept of equité rather than a concept of equity, which is dealt with in the Jersey Appellants case. So trusts existed before the 1984 law in Jersey, and similarly, Roman law is a source of the Jersey customary law of hypothek. Interestingly, the hypothek is also likely to be the source of equitable liens. And if we can turn to page 3993.
Sorry, can you give me that page number again, please?
Of course, 3993. This is Burns. And there, while legal historians have suggested different origins for the hypotheca, it laid the foundations for modern securities which did not require possession, most notably the mortgage and the equitable lien. It was equally important that the hypotheca was capable of being created by the agreement of the parties or created by law. The latter was known as the legal or tacit hypotheca. In turn, the tacit hypotheca was divided into two kinds. And then they go on to say historians of Roman law have drawn modern comparisons between the equitable lien and the Roman hypotheca. However, it is unclear to what extent the hypotheca was known to English lawyers prior to the 18th century. So similarly, this right of hypothek, which is known in Jersey, was the start of the rights which then became known as the equitable lien rights in England, because a hypothek is actually a pretty good description of the kind of rights that we look at here. It is by operation of law, and it is non-possessory, and you'll see a security imposed by law over either specific property or the entirety of the property. And I'll come back to how Jersey law treated a hypothek, because in actual fact, the hypotheks were always treated as being arranged first in time. in the same way as equitable rights. But for the current purposes, the important point being that then hypothec can be traced into the Jersey customary law of hypothecation, and that governed prior to the 1888 law. Now, if we can look at, please, there's a very helpful article by Omar, which appears at page 4330. This is a quite comprehensive review by Paul Omar of the security reforms and the legal transplants and the conflict between civil law and common law systems. And as well, it looks at the background to the Security Interest Law 2012. So if we can look at, first of all, this merits reading in full because it deals with the Jersey position as regards security over tangible movables. But if one starts at paragraph 10, or in fact paragraph 9, that describes how the hypothecation of movables came to be doubted as possible in Jersey in cases such as Haley and Bartlett, where the court was of the view that movables cannot be the subject of hypothecation and may not be sold or transferred by deed, by way of guarantee in instances where actual delivery has not been made to the creditor. Now, at paragraph 10, Omar goes through the reasons which were advanced for that change in position. And note that that is a change in position in Jersey. So originally, hypothecation was possible, and then there's this doubt. The reason for that is put as point 1, the influence of the codification process leading to the adoption of the French Civil Code, which swept away the variants in provincial customary law and which the hypothec came to be restricted to immovables. And then 2, the advent of the customary law doctrine of apparent wealth, under which movables cannot be hypothecated, i.e. without transfer of possession, because to leave the goods in the hands of the debtor would give a false view of the debtor's creditworthiness, possibly misleading others as to his standing with respect to property and ability to repay. So those were the overriding considerations which led Jersey to say hypothecs are going to be limited to immovables and not going to be possible for movables. And if one goes on to paragraph 11, in Jersey, the position was rendered more certain, because there was doubt at that stage, by the passing of the Loi 1880 sur la propriété foncière, Article 2, of which defines the hypothec as a real right attached to a rent or other claim, by virtue of which one or more parcels of a movable property, which is a corps de bienfait, is especially dedicated to the repayment of those obligations. And further down, Article 3 goes on to say that a hypothec may only be created in respect of immovable property. If we then move on to paragraph 14, that describes a pledge over movables. As such, the only permissible device for the securing of movable assets is the pledge or gage with possession handed to the creditor. The device of effecting constructive delivery seen in English law is apparently unavailable in Jersey, perhaps also because of the effect of the doctrine of apparent wealth. So at that stage, the permissible advice was this notion of the pledge, And you will have seen there is reference to a pledge in John Martin's judgment in the Court of Appeal. So he, when he disagrees with the learned bailiff, says it may be seen more in the nature of a pledge in Jersey than anything else. But in fact, if I can take the court through, that distinction may not needed to have been made. If we can then, before we go to look at the security interest law, if we can look at the purposes behind or the intentions to actually create that law, and that's dealt with further in the article at paragraph 22, that's at page 4339. So could I ask the panel to read that paragraph, please? So the point being that the purpose of the security interest law was to combine many different security interests that are available in Jersey, including the hypothek or charge. And the idea is that you would have one central place which you would be able to create security interests. And remember, this is security interests over Jersey property. There has been recognised, and you've always been able to have other foreign law governing other security interests, which weren't possible under Jersey law. But that was the purpose of the 2012 security interest law. It was to make sure that this bundle of security interest rights, including a hypothek, were included within one easy statute. And it was designed to make Jersey more financially beneficial in terms of these kinds of arrangements. So with that all being understood, could we now move to the security interest law? And that appears at 3837. If we can start with the definitions. So if one looks at the definition of security interest.
Can you just remind me, Ms. Jordan, is this statute, obviously this is a 2012 statute.
Yes.
Is it relevant to our case?
It is, yes, Your Lordship, it is. So if one looks at paragraph 1A, which is page 3847, there, paragraph 1A1, in this law, security interest means an interest in intangible movable property, being an interest that, under a security agreement, secures payment or secures the performance of an obligation. So that is the definition of the security interest there. And then you have part 2, article 4, the application of the law. So this law applies only to the following, and there you've got the Jersey situated assets. It concentrates on the assets which are Jersey based. I won't take the court all the way through that. But the important point is at Article 8 of the 2012 Security Interest Law. Those are the interests which are excluded. So at Article 8, subparagraph 1, except as provided by any order made under Article 4C, this law shall not apply to or in respect of or affect any of the following interests: a lien or other encumbrance or interest in movable property created by any other enactment or by the operation of any rule of law. So what that does is accept as a matter of Jersey law that liens, not simply liens by way of enactment, not simply liens which are statutory, but liens or other encumbrance or interest in movable property can be, and those which are created by the operation of any rule of law, those are not affected in relation to the security interest law. So they are possible over movable property. That is what that exclusion means.
Of course, that's not in doubt. The bailiff explains to us that there are well-known categories of lien, for example, a solicitor's lien.
Yes, Lord Reid, but the bailiff doesn't go far enough in his judgment, and this is why I say it's his preliminary view, because my point about Article 8.1 is that goes very much further for the narrow categories which the bailiff was contending for. So our case is that a lien that we are talking about, a trustee's equitable lien, arises by way of operation of law, and that is sufficiently captured in this exclusion. So there is nothing on these terms inconsistent with Jersey law permitting a lien or other encumbrance or interest in movable property created not only by statute, by the operation of any rule of law. And if I can just finish that point in terms of the security interest law, because when we looked at Omar, it clarified that hypothecs, which was the original right, and this is what the bailiff was focusing on, because that is known as the non-possessory security in Jersey law, and hypothecs were meant to be included in this law, and they are expressly included. So if one goes down to Article 15, and one can see that at page 3854, security interest created by agreement, and at 15.2, for the avoidance of doubt, a security interest in the nature of a hypothec may be created over intangible movable property. So that does expressly abrogate the rule that the bailiff is discussing. And there's a reason for that, as Omar has said, because the whole point of this law was meant to clarify the position of Jersey law as regards security interests.
And is this talking about the creation of a security interest of that kind by a security agreement?
It's in the nature of a hypothec, Lord Reid. So
Yes,
you're quite right. The title suggests it's created by agreement, but that would have to match the fundamental requirements of a hypothec.
Well, we have a definition, don't we, of a security agreement earlier in the law.
We do, Lord Reid, but this is for the avoidance of doubt. So it is preserving. It is saying that a hypothec may be created over intangible movable property. It's expressly giving that ability.
But when you say expressly giving that ability, are you saying that this is created by Section 15, or that this is just preserving a pre-existing ability?
I'm saying, Lady Rose, that this is saying may be created over intangible movable property. So it's clarifying that doubt, if one existed, in relation to a security interest in the nature of a hypothec.
Well, Mr. Jordan, if you see the words in 15.2, a security interest.
Yes.
If you go back to section 1A, which you took us to,
Yes.
on page 3847, in this law, security interest means an interest that under a security agreement secures and so forth. And then the words security agreement are defined further up the page as meaning an agreement that creates or makes provision for a security interest.
Yes.
Right. Okay, so that's what we're talking about.
Yes, but in terms of, I mean, one can't take away from the purpose of Article 15.2, and Omar specifically refers to it as Article 15.2 allowing hypothecs to be a security interest over intangible movables. Yes. That is the purpose of 15.2.
Yes, but are you saying that in this appeal we're dealing with a security agreement within the meaning of?
No, Lord Reid, I'm not. My
Article 15.2 shows us that it's possible under the law of Jersey to create a hypothec over intangible movables, but this isn't an appeal. This isn't a case in which that's been done.
No, there is no agreement in relation to a hypothec, but the point, and if one goes back to Article 8, that the bailiff was making, it is not necessarily correct, because the point of the Security Interest Law 2012 was to include hypothecs. So his customary law point that this concept of a non-possessory lien is fundamentally inconsistent with Jersey law in terms of security interest law, it is not correct, because
he didn't say that. He was saying that the concept wasn't known to the customary law of Jersey, and that to the extent that remained the position, except to the extent that statute had innovated upon it. And he referred to the security laws of I think 2003 and 2012.
Yes, the 1983 and the 2012. Yes, that's quite right, Lord Reid. He did refer to those, but he didn't expressly refer to Article 8 or 15.2, both of which are important when one considers the principle which is being suggested, which is that a non-possessory lien is inconsistent with Jersey law. Yes, Lord Patton.
I mean, if I can just sort of ask a question that follows from that. I mean, following up what Lord Reid's been asking you, I mean, what is the effect of 8? I mean, I follow that where you've got an agreement, you can now, under Jersey law since 2012, create a hypothec over movable property.
Intangible movables, yes.
Intangible movable property by agreement. That's clear. So that takes that out of customary law. But as far as 8 is concerned, 8 excludes, I think, the a lien or similar interest in movable property arising by operation of law.
Yes.
So is this right then, that they are not, they don't get the benefit of the provisions of the 2012 Act, in other words, the bypass of customary law? And is one then left to go back to customary law to decide whether by operation of law you would infer the existence of that sort of interest?
No, the point about Article 8, and it might be useful to go back to the Omar article, because he deals with Article 8. Perhaps that's the easiest way to go back. So I think it will be at page 4338. There are liens. He says the mention in Article 8 of the Security Interest Jersey Law 2012 of the exclusion of a lien or other encumbrance or interest in movable property is wider than just a lien created by any other enactment or by the operation of any rule of law, means that liens are recognised to exist over movables. And that is Jersey law. That is the purpose of excluding it from the security interest law. It's saying that liens are recognised to exist over movables, and it's those liens created by any other enactment or by the operation of any rule of law.
But I don't understand that, because if that's right, you don't need the provisions that the 2012 Act introduced.
Do you mean you don't need them to be complete?
Well, I mean, I thought the whole point of the 2012 law was to avoid an argument, if I can put it that way, about whether at customary law you could create that sort of security over movable property, intangible movable property. And it makes it clear that you can now do that if you do it by way of an agreement.
Yes, or well, that's the hypothec point. But yeah, as regards Article 8,
but it says that this has got nothing to do. These provisions don't apply to anything that implied as a matter of the operation of law.
Yes.
So as far as that area is concerned, why isn't a relevant consideration then in relation to Jersey law what the customary law position is, apart from the 2012 Act? I mean, I just can't see how the exclusion by Article 8 from the provisions of the 12 Act puts you in the same position in relation to interests that are not covered by the 2012 Act.
Well, it might be said, Lord Patton, that it allows the question to be begged as to whether, in fact, there is a lien in Jersey law which arises by operation of law. The point that I make about Article 8 in the security interest law is the point that Omar makes, which is that liens are recognised to exist over movables. You're quite right that if in actual fact Jersey law doesn't recognise this particular lien, then Article 8 doesn't help me in that sense. But what I'm saying is the existence of a lien over movable property is not fundamentally inconsistent with Jersey law.
Of course it's not. The whole argument is about what in Jersey are called hypothecs. And hypothèque over, it's more than un point de suite par hypothèque. Movable properties, you can't have a hypothèque over a movable property. That's to say, a non-possessory right and security. And this act is making it possible to have exactly that. It calls it a lien, following the English terminology. And section 12, article 12, tells us how to do it. And article 8, I think, is simply making it clear that the act doesn't affect the existing law of liens, which would include, for example, liens over a solicitor's lien over his papers, or we're told there's a statutory lien over shares in companies in respect of debts owed in respect of those shares. No doubt there are other examples.
Yes, but it's not limited.
Unremarkable provision.
Well, it's not limited in that way, Lord Reed. The article actually is quite wide, and it does say the exclusion of a lien or other encumbrance or interest in movable property created by any other enactment or by the operation of any rule of law. Yeah. So it is wide. It's not limited to specific categories of liens.
If you're looking, if to cut to the chase, if you're trying to tell us that the implication of Article 8A is that it was possible for a trustee to have a lien or encumbrance or interest in movable property following his resignation as trustee, the property being the trust fund, you would have to look for some other enactment which created it, or the operation of some rule of law that created it. Now, you're not suggesting that it was created by any other enactment, and so far as any rule of law is concerned, as Sir Nicholas has been putting to you, well, we seem to be talking about the customary law.
But in terms of an answer to that, as John Martin said in his judgment, what we are actually looking at here in terms of the trustee's rights of being a trustee is whether that was incorporated into Jersey customary law by the English law, whether Jersey accepted that into its law as part of a modification to its law. And I'll take you, if I may, to that judgment now. Lord Stevens, before we
add to your woes a bit. I just cannot understand how it can arise by operation of any rule of law if it's contrary to customary law. So the anterior question is, what was the customary law? Anyway,
do you mean...
I'm sorry for piling on the woes.
No, don't worry. Can we, before I answer that, can we go back to John Martin's judgment in the Court of Appeal? That's at page 449 of the bundle, and this is him responding to the learned bailiff. This is how he answers the point in terms of the customary law position, and this is a point I also adopt. That the key point about Article 8 is that the security interest law excludes those liens, and those are quite wide liens. What John Martin says in relation to Jersey law is there at 285, he goes through the trustee's lien is an inseparable incident of his office. And then he goes through the kind of cases that we've seen and Abdul Rahman. And then at 286, accordingly, it seems to me that there is no actual tension between Jersey customary law and the requirement to recognise a trustee's non-possessory lien. the lien arises from a structure foreign to Jersey customary law, and that nevertheless exists under Jersey law and did so before enactment of the trust law. And the incidence of the structure must be regarded as consistent with Jersey customary law. The importation of the alien structure necessarily involved importation of essential elements that would otherwise have been alien to the customary law. So, and then he goes on to say that the reference to Article 11.2 rather begs the question. If the trustee's right of lien has been imported into Jersey law as an essential incident of the recognition of trusts, it is not contrary to the customary law. But even if contrary, the tension exists, and then he goes on to Investec. So that is really the point as regards this trustee's lien, as opposed to other liens.
Is the learned justice of appeal not proceeding on the basis that he's bound to follow what was said in Investec 1? If you go back to paragraph 283, he refers to the tension between what was said in paragraph 57 of Investec,
yes,
the overriding nature of the Jersey customary law, and the statement in paragraph 59, which is the one about liens. And he says one of the principles that must be regarded as part of Jersey law is that a trustee has an equitable lien that does not depend upon possession. Now that's his
yes.
key, because that's the proposition which the bailiff rejects as a matter of Jersey customary law.
Yes.
I think the Justice of Appeal here is telling us that as a result of Investec, paragraph 59, one of the principles that must be regarded as part of Jersey law is that there is such a non-possessory lien, and the tension arises because Jersey customary law doesn't in any other context permit the creation of a security of that kind. And that then goes straight into English authorities in the next couple of paragraphs, starting chronologically with the Exwall case.
Yes, but what he says at 286 is, in his view, that there is no tension between Jersey customary law and the requirement to recognise a trustee's non-possessory lien. He does say that in terms. The lien, and then he says the reason he says that is because the lien arises from a structure foreign to Jersey customary law that nevertheless exists under Jersey law and did so before the enactment of the trust law. And the incidence of that structure, i.e. the important incidence of the trust, must be regarded as consistent with Jersey customary law.
So what he's saying and you're adopting is that by accepting into Jersey law, trust law from England, that must include the incidence of the trusteeship, and that includes this unusual non-possessory lien over the trust asset. And Article 8 of the 2012 law shows that that can still remain. It pre-exists, and it may be a quirk, an exception to the general Jersey customary law with which the learned bailiff was concerned, but there it is. It's an incident of this alien structure and has been since trust law was introduced into Jersey. Is that what you're saying?
That's exactly right, Lady Rose. That is precisely the point. That it's where we started this afternoon, because of the nature of that right. And I go back to the point that this is as true for Jersey trustees as it is for English trustees. And that is why we start with Article 8, and you see that excludes these, and it is wide enough to include that. And I do pray and aid John Martin's view and his judgment that the lien arises from a structure foreign to Jersey customary law, but it was bolted on because it is so important.
Well, his reasoning, I think, at 285 first sentence is that the trustee's lien is an inseparable incident of his office. And then 286, when he talks about the structure foreign to Jersey customary law, he says the incidents of the structure must be regarded as consistent with Jersey customary law, and the importation of it necessarily involved importation of essential elements. So the underlying proposition is that the non-possessory lien enjoyed by an English trustee after his resignation from office is an essential incident of trusteeship. You can't have a law of trust without it.
Yes, yes. I mean that is what the learned judge is saying. That's right, Lord Rees. That is what he's saying.
Well, you only have to go north of Berwick to find one legal system that has a law of trust without it.
Yes.
But how does that sit with what Lord Hodge says in his own judgment, or the board's opinion in Vestec, where he says that trust law, I mean, I'm paraphrasing now, trust law been imported, but with whatever modifications are necessary to take account of Jersey customary law.
Yeah, but that becomes very difficult because in this case, what I say in reliance upon John Martin's judgment is that this was something which was unknown at the time to Jersey law, but nevertheless existed under Jersey law because it was an inseparable incidence of trusteeship, and so had to be there. And if we go back to the policy reasons that one was looking at the movable point, and it was only movables that there was this distinction, and it was assets within Jersey as well, that those don't apply to trustees, because of course that kind of doctrine of apparent wealth is not really something which is applicable. Trustees are the owners of the assets, so we're talking about something very different here, and that's really important to understand as well. Lord Briggs.
Is a possible explanation of this, and I'm really putting it forward to you for your comment, that if the true nature of what we have chosen to label the trustee's equitable lien is that a trustee, including a former trustee, is entitled to go to court and ask the court to direct whoever happens to be the current trustee or receiver or other person in control of the trust fund to apply it so as to give effect to his indemnity, that is proprietary in the sense that it's not a personal right against a particular person, but a right to go to court and ask that anybody who has control of this property deals with it in that way, that simply isn't a hypothek.
Yes,
and on hypotheks over movables.
Yes, that's exactly right, Lord Briggs. And can I, if we've moved from the position as regards liens under operation of law and John Martin's judgment, then there is a separate point about this notion of a preferred beneficial interest in Jersey law, and that notion of equitable.
I'm trying to avoid labels and just refer strictly to what the right enables you to do in the most protean and down-to-earth way, because it seems to me that, if nothing else, this whole piece of litigation is the victim of labelism.
Yes, and that's agreed. The labels are often unhelpful, particularly when one looks at, and it is difficult when one looks at Jersey law, which is a system carved out, and it imports a system of English law trust to it on its existing Jersey customary law. But if we can now look back in that more general sense, in terms of what we're looking at.
Sorry to
oh, I'm sorry.
At that moment, but there's just one thing that you said a little earlier I just wanted to go back to, and I'm not quite sure whether I noted it down correctly, but you did, I think at one side you said it's always been possible for Jersey trustees to have foreign security arrangements.
Yes.
So if the trustees of this trust had a bank account or in the Cayman Islands or BVI or anywhere else, does it follow that Jersey law would not prevent having an equitable lien over that bank account?
Yes, and that's dealt with in the article at Omar as well.
Well, I know, but I'm sorry to interrupt you, but I imagine these trusts had many assets which were outside Jersey.
But this is the difficulty, Sir David, because if you look at things, and this is why the term security interest is sometimes very ambiguous, because it depends on the circumstances, because the whole purpose behind the security interest law was to deal with Jersey property. And hypotheks, of course, were distinguished between movables and immovables. But you can't possibly start distinguishing between different forms of assets that the trustee has, because you basically be saying then that as a matter of Jersey law, it has the ability to have a non-possessory lien over certain assets, but not others. I
don't quite see why Jersey law prevent the trustees of a trust governed by Jersey law having an equitable lien over a bank account in London.
Yeah.
No, it wouldn't, Sir David, that's right.
So, given the nature of the assets we're talking about, of which we have no information, I think, this may not be, in practice, a very important point.
Yes, I mean, the difficulty is that you then have to specify that the assets are all non-Jersey assets.
So, yes, you'd have to do that, but I understand. I understand.
But you're quite right. You're quite right. As a matter of Jersey law, it is possible, and the laws deal with that, to take foreign security under foreign law. So you could take an equitable lien under English law over an asset which is in England, for example.
I suppose the trouble is this arises by operation of law, not by contract. So the only law under which it could arise is Jersey.
Exactly. The key point, yes, exactly. The key point is Jersey law applying. But you're quite right, from a matter of practicality, that is right.
All right, thank you.
Could I therefore then look at, and it's helpful for us to look at the Guernsey Court of Appeal decision in Investec, because we were looking at yesterday the rights, the arguments at the Privy Council, and it was said that the issue of whether Jersey recognised this equitable lien was conceded. In fact, as I understand it, and having spoken to Mr. Taub QC, that was argued before the Guernsey Court of Appeal. And in fact, that judgment appeared in the judgment of the Commissioner when he recognised an equitable right. And if I can go to... I believe it's that paragraph 23, page 23 of the bundle. I might be approved one. Yes, that's right. So this is the judgment.
Are we looking at the Guernsey bundle?
It's the Jersey bundle.
Jersey,
and yes, Jersey bundle. I'm sorry, and it's page 23. This is and you should have a judgment of Commissioner Clyde Smith on the 12th of February 2015. That is the judgment where the Commissioner determined whether an equitable lien existed. And if we can just look through this judgment. So at paragraph 3, he says to talk of an insolvent trust is of course a misnomer. A trust is not a separate legal entity and cannot, as a matter of law, be insolvent. And then he says it's a useful form of shorthand and I will continue to use it. And then if we move down in the judgment, he says, paragraph 10, equity is concerned to ensure that its asserted equitable lien over the assets of the Z2 Trust are not, in the words of Justice Brereton in Lemery Holdings, destroyed, diminished or jeopardised. And that's that phrase that we saw earlier. In its view, the appointment of a non-resident trustee would make enforcement of its rights under the indemnities and under its separate equitable lien more difficult. And then at paragraph 12, this is where he considers the issue of whether Jersey law recognises the existence of a former trustee's equitable lien, as Advocate Renouf had not conceded its existence. And at the time I relied on the Guernsey Court of Appeal judgment, and he goes into what that case dealt with. And then he says, with the agreement of counsel in that case, the Court of Appeal, which comprised James McNeill QC, John Martin QC and Robert Martin QC, construed Jersey law as if it were construing a statute of Guernsey. In construing Article 32, the Guernsey Court of Appeal held that a trustee who has transacted has a right to be indemnified by a subsequent trustee out of and up to the limits. And then they quote from paragraphs 34 to 37 of the judgment. Could I ask the panel to read those paragraphs which refer to the Guernsey Court of Appeal judgment? And then after quoting those judgments from the Guernsey Court of Appeal, the Commissioner at paragraph 13 accepts that the judgment is not binding on the Royal Court, but says, in my view, that decision does reflect the law of Jersey, and accordingly equity as a former trustee does have an equitable right in the sense described by the Guernsey Court of Appeal in Investec, and is entitled to ensure that Volar and Barclays do not take steps which will destroy, diminish or jeopardise that right. That equitable right will, of course, only extend to the liabilities for which equity would have been entitled to reimbursement out of the trust fund if it had remained trustee, i.e. liabilities reasonably incurred in connection with the trust, and both Volar and Barclays have reserved their position in this respect. And he says it may be that creditors of the trust may wish to do the same. Just to finish at that point, can we then go to re-esteem, which is at 1262. The case actually starts much further back, but this is the 1262 is the beginning of the proprietary tracing claim. And if we go down to, does the victim of fraud have an equitable proprietary interest in the proceeds of fraud? And if we look at first at paragraph 83, could I ask the panel please to read paragraphs 83 and 84?
Page reference again.
Yes, of course. Paragraphs 83 and 84 are at 1263.
Thank you.
And then moving further down at paragraph 87 and 88. And then just finally at paragraph 90, and these were all the paragraphs which are cited in the Guernsey Court of Appeal decision. Finally, at paragraph 90, just those last few sentences, we have no doubt that Jersey law should draw on the experience of English law and other jurisdictions to impose a constructive trust in the case such as the present. We think that in Jersey too, when property is obtained by fraud, equity imposes a constructive trust on the fraudulent recipient so that the victim has a proprietary interest in such property. So that is the learned Deputy Bailiff, Michael Burt, as he then was. And it was those paragraphs which founded the decision of the Court of Appeal in Guernsey in relation to the rights, this idea of the ability to have equitable proprietary rights, notwithstanding the distinction which was raised in this case in relation to the civil law as opposed to English law. And we would say it would be very strange if equitable proprietary rights could be recognised for beneficiaries and third parties, albeit in this situation under a fraud circumstance, but subject to a constructive trust. And yet the former trustees, for example, did not have the same equitable proprietary rights. And I'll move on to the concept of the Trust Jersey law tomorrow, because we're at 4 o'clock.
Have we looked at all the relevant authorities on this point about the interaction between the legislation and customary law? Are there any others?
Do you mean the interaction between, Lady Arden, do you mean the interaction between the security interest law?
Yes, the 1984 legislation I was thinking about here.
I'm sorry, the TJL legislation. Yes, so we will look at the TJL, but these are the main points in relation to the rights that arise under an equitable proprietary basis. Yes, re-esteeming. Yes. Those are the references that were relevant for the Guernsey Court of Appeal when recognising a trustee's rights according to Jersey law.
And there clearly has been a very vigorous debate.
Yes, and that's what I understand from my learned friend Mr. Torb QC in relation to the Guernsey Court of Appeal judgment, that there was a debate on that issue. So whilst it might have been conceded by Lord Goldsmith in the Privy Council, that's how it was determined and argued at the stage of the Guernsey Court of Appeal.
Thank you.
Yes, well, thank you very much, Ms. Jordan. You've given us plenty to think about. We'll resume tomorrow morning at 10:30.
Thank you.